That's a direct breach, I think, of the plain and simple terms of your note. It'll usually say use of proceeds or payment, application of payments, and it will say any payment you make is to be applied to your loan and nowhere else. In fact, they weren't doing that. They were uh, commingling the income streams, and that's how the servicing companies get more money, actually get paid income higher for a non performing loan, which by definition is one which is not being paid, than they get paid for a performing loan, which by definition is a loan upon which the borrower is making payments. Well, how could the servicer be getting paid on a loan that is not being paid? Well, the answer is they're taking it out of the pool. And now there have been lawsuits in which it is alleged, and there have been some preliminary findings which show that the commingling of those funds is improper, possibly fraudulent, probably a breach of fiduciary duty, and certainly wrong from the perspective of the borrower and the investor. So, when you're researching your particular loan, whether you're a lawyer researching on behalf of your client or a homeowner who's researching your own loan, take a look at the different forms of insurance, title insurance, property insurance, PMI, etc., and take a look at whether or not you've been contacted by somebody who says they're a trustee now for a pool of assets or a trust which supposedly now owns your loan by an assignment or something they might call an allonge or something they might call an endorsement. These factors on the insurance beneficiaries might directly contradict the first assertions that your would-be forecloser would make in court. They're going to come into court and they're going to say that we're the holder of the note, we can enforce the note, we can foreclose, and all the other things that they can't do because they never advanced a dime on your mortgage and they are therefore not the creditor. And the typical problem that many people have on the homeowner side is getting a judge to consider the possibility that that is a false statement, which it almost always is in a securitized loan situation. I won't say that it's 100% true, but I will say that in my opinion it's 99.9% true that anyone in a securitized loan situation other than an investor who comes into court and says that they have a right to foreclose on the mortgage or deed of trust or enforce the note is at this point misrepresenting the facts. The problem is that in most judges' minds, foreclosure is a simple thing. You have a lender, you have a borrower, they either made the payments or they didn't. And it's difficult, challenging for any judge who has been sitting on the bench for any length of time to absorb the fact that it may not be so simple in a securitized loan. But it may be very simple for you to show the question of fact, which is all you need to do in order to get to discovery and an evidentiary hearing and potentially get awarded a temporary restraining order. You may be able to show it very easily when you start comparing the beneficiaries under the various title policies. And you can say, Judge, all I know is I've contacted these insurance companies. I've asked them if the payee and beneficiary are the same, if there's been any changes, and they say no. And here are the policies. And if they are the creditor, what are these people doing as the beneficiary under these policies? That's going to create a problem for them right away. Hi, I'm Neil Garfield, editor of the blog site www.livinglies.wordpress.com. And I'd like to invite you to purchase a copy of the DVDs of the seminar that we gave in San Diego for laymen on the steps involved in defending your property, selecting an attorney, selecting a forensic reviewer or TILA auditor, and the basic facts concerning securitization of your loan. Watching this DVD will enable you to have attended the workshop without ever leaving your home. There is a workbook that is also available that goes with this. You have the option of just watching the DVD, getting the workbook, one or the other. I would recommend that before you take any action on your own behalf, and certainly I recommend that you consult with legal counsel, that you watch this DVD, get the workbook. You'll be much better informed, and you'll be in a much better position to make a decision about how you want to defend your home or what you want to do about a mortgage that is unfair and underwater.